Good afternoon and welcome to our webinar. The UK left the European Union over 20 months ago, and we thought it would be interesting to look at what UK trademark proceedings look like in a post-Brexit world. During the next 45 minutes, we will look at the impact Brexit is having on trademarks. First on trademark filing, but also on the prosecution process and on registry dispute and infringement action. We will highlight divergence between the UK and the EU IPO approach, and we will leave you with some practical tips so that you can use to improve your client future filings, but also enforcement strategy in the UK. With me today are two other members of the IP and media team, Julia King and Lara Pentris. Julia is an associate and trademark attorney. She advises clients on all aspects of brand protection, including clearance, filing, prosecution, exploitation, and enforcement of trademark and design worldwide. Lara is an associate and solicitor. She advises clients on both contentious and non-contentious soft IP matters, including trademarks and design and copyright disputes, look-alike, comparative advertising, and all types of commercial transactions involving these rights. My name is France Delors. I'm a partner with Taylor Wessing in London, and I have over 25 years' experience in brand management as well as in cross-border trademark litigation. Before we start, two housekeeping points. This seminar will be recorded, and we will, of course, share the recording with you. If you have any question and have not been able to send your question before the start of the seminar, please send them in the chat, and we will try to address them at the end. But let's remind ourselves of the event leading to the UK exiting the EU. In a referendum held on the 23rd of June 2016, the majority of those who voted chose to leave the European Union. On 29 March 2017, the UK Prime Minister formally triggered Article 50 and then began the 2-year countdown period for the UK to formally leave the EU. As we know, Article 50 was extended twice. Between June 2017 and October 2019, the UK and the EU negotiated the withdrawal agreement. On 31st January 2020, the UK left the EU and entered a transition period, which ended at 11 p.m., midnight in Brussels, on the 31st December 2020, and the UK then left the EU single market and custom union. The first impact of Brexit can be seen in a sharp increase in activities at the UK IPO. In 2021, the UK IPO saw a 43% increase in the numbers of trademark applications. However, in the first half of 2022, the IPO statistics show a 90% fall in the numbers of trademark applications made during the first half of 2022 compared to 2021. However, this activity remained well above the pre-2020 levels. Likewise, the numbers of opposition filed in 2021 has increased significantly, and Julia will give us more detail about this. We have also seen a sharp increase for design. But let's go into details with Julia and look at what exactly happened at the end of the transition period.
Thank you, France. Perfect. So since the end of the transition period, all EU trademarks which were registered as of the 31st of December 2020 have been converted into UK comparable rights automatically and replicated on the UK trademarks register. So they're there, they're visible, and they're online. We can identify these trademarks by the numbers which prefix them. So 0080 for a trademark which was formerly an EU designation of an international registration, and 0090 for trademarks which were formerly EU TMs. This automatic process of converting EU rights into UK registered rights ensures that EU rights holders have not lost any protections in the UK as a consequence of Brexit. No new registration certificates were issued for these comparable rights, but we can request certified copies of them if the need arises for a small fee. So that's the situation for established brand owners in the UK at the moment. But what now for companies who are interested in protecting their new brands in the UK and the EU going forward? Separate filings are necessary. And there's two routes to do this. One being via WIPO, the international route, and the other being via the UK IPO, the national route. And I'll touch on both of those now. So in our view, it's preferable to apply to register a trademark in the UK via the national route, which is directly with the UK International Property Office. This is because WIPO filings, which are made by the International Bureau, are bound by the details of a foreign-based registration, which means that any objections which are raised by the national office, for example, to descriptions contained within the trademark or to classifications of the specification, these cannot always be amended at the UK IPO. So in the worst case scenario, for example, an objection to an unclear description contained within a UK designation, which cannot be amended at the UK IPO, nor at WIPO, being an administrative body, and nor in the original base registration, which has since registered at a foreign registry, may result in the refusal of a UK designation. On the flip side, if you were to file a trademark via the national route at the UK IPO, it's possible to amend the description for clarity, it's possible to amend the specification to resolve any deficiencies in drafting much more easily. And this means that examination objections are much easier to overcome nationally at the UK IPO than for UK designations filed via WIPO. It's also straightforward to assign trademarks and to update owner details at the UK IPO. For assignments, simple copies of assignment agreements are helpful, and they will be kept confidential by the UK IPO. And all that's required for assigning and recording transactions on the UK register are the details and those copies of those agreements. No powers of attorney or other documentation is necessary. So for filing at the UK IPO, let's talk the national process. All that's required to file a UK trademark application is a copy of the mark, so a JPEG if it's a device mark, the proposed specification of goods and services, and the owner details and address. No documentation, again, no powers of attorney or certificates of incorporation are necessary. And costs are reasonable. So filing an application for one mark in one class will cost around £170 in official fees, and there are further costs for additional marks, additional classes, etc. Now, the UK IPO hired a vast number of new examiners since Brexit because it expected an uptick in applications. And so we're currently seeing applications being examined within 10 days. So this means within less than a fortnight, we'll know whether there are any objections to the application on absolute grounds or any objections to terms in the specification, for example, which is a very quick examination process. Now, unlike some other national registries in the EU, such as Sweden and Ireland, for instance, the UK IPO does not raise earlier rights as an obstacle to the acceptance of a trademark application. So this means that brand owners will not receive citations against their application. They may, however, receive a list of earlier rights which the examiner thinks are similar to the proposed trademark for which is being sought registration. So unless those earlier marks are removed by the owner through argument, or unless the application is withdrawn, the examiner will notify the earlier rights holders that own similar trademarks and give them the opportunity to object to the application when it's open for opposition. The opposition period in the UK lasts for 2 months and can be extended by 1 month through the filing of a notice of opposition. Extending the deadline gives a potential opponent the opportunity to try and resolve dispute amicably with the applicant. Oppositions in the UK can be filed on absolute grounds and based on earlier rights, and those earlier rights can include trademarks, designs, copyrights, and unregistered rights, and other sorts of rights in the UK. Unlike at the EU IPO, UK opponents can oppose a trademark application in the UK based on bad faith too. By far the most common ground of opposition, though, is conflict with an earlier registered trademark, as you'd expect. And over 8,000 oppositions were filed in the UK last year, which is a nearly 200% increase on 2020. we recommend that clients conduct full availability searches prior to filing their trademark application in the UK to help determine the level of risk posed by earlier rights holders. So full availability searches will help to identify earlier trademark applications and registrations, and common law searches can help to identify brands which may hold unregistered rights in the UK. So they're not present on the register, but they've been in use potentially for a significant time in the UK and may also be an obstacle to a trademark application. Once the trademark has been registered, the owner has a 5-year period in which to put it into use in the UK without challenge. So that's harmonised with EU law, the 5-year period for use. Renewal is 10 years from the filing date of the trademark application. And it's good practice for brand owners to maintain an evidence bank of UK-specific use of its trademark in the event that it's challenged on the grounds of non-use by a third party. So the relevance of that post-Brexit is even more important because it will be separate from the EU registration, and UK-specific evidence such as UK invoices, supplier contracts, advertisements, and other materials will be necessary in the event of challenge.
Okay, so now you've got your right registered, we're moving on to enforcement, and these are some preliminary considerations both from a registry perspective and also in a court action. So a key question before commencing any action, and that's regardless of the location, is what rights does your client have to rely on in that territory? In the UK, this can be split into registered trademarks, including, as Julia just mentioned, the UK comparable rights to existing EU trademark rights created post-Brexit, unregistered trademarks in the form of the common law tort of passing off, and, as Julia also mentioned, other rights such as copyright, design rights, GIs and PDOs. So looking into passing off in a little more detail, as this is specifically unique to the UK, passing off constitutes a common law tort which can be used to enforce unregistered trademark rights in the UK. Passing off can be used to protect rights in names, symbols, logos, packaging, get-up, trade dress, and advertising styles or slogans, which have been used by a client and, as a result, have become associated with their business. To establish passing off, the client must satisfy each element of the classical trinity. That is, that the client must have goodwill in the UK in relation to the particular goods or services in question. The opponent must have made a misrepresentation that is likely to deceive the public, and mere confusion in the minds of customers is not enough. And that misrepresentation has or is likely to damage the goodwill. So focusing on goodwill in a little more detail, this is the attractive force which brings custom in. So it must relate to the buying or selling of goods and services or dealing with customers. You should bear in mind that goodwill is localised, and the scope of such unregistered rights acquired through use will be limited to the geographical area to which the business is known in the UK. So taking, for example, it could be localised in London, or it could be in a little small town in Harrogate up in the north of the UK. It can also be across the UK, so it's just something to bear in mind. Further, if a non-UK entity is involved, goodwill will arise in the UK where there is sufficient trade presence in the UK, and this can be evidenced by customers or sales in the UK, and reputation in the UK is not enough. So the next question you might want to ask yourself is, does your opponent have any prior rights in the UK? So aside from considering your own rights, consider whether they have any earlier registered trademarks or unregistered rights acquired through use of the sign. For earlier registered rights, prior registrations in the EU can no longer be relied on to invalidate or oppose UK trademarks with a filing or priority date after 31st of December 2020. However, there will likely be a comparable UK right which could be relied on for either an invalidation action launched or opposition filed on or after 31st of December 2020. For earlier unregistered rights, you want to ask whether there has been any prior use of the sign in the UK and whether that use is sufficient to have attracted goodwill, as we've previously discussed. Before taking any action, we would conduct the necessary prior use searches, and that's something we can do for you here at Taylor Wessing, and that includes hiring private investigators to ascertain the extent of the precise use and when it started. If you are looking at registered rights, you want to ask how old the rights are and whether they're vulnerable to attack. So, the non-use position post-Brexit. We all know that if rights are over 5 years old, the rights could be put to proof of use. So, for example, a defendant to trademark infringement proceedings could require that as part of the claim. Genuine use of an EU trademark in the EU 27 on or before the 31st of December 2020 will count towards use of the comparable UK registration if it is within the relevant 5-year period. So this means that a comparable UK registration cannot be revoked for non-use until at least 5 years after the last genuine use in the EU on or before 31st of December 2020. So this use could potentially extend the life of the mark to 1st of January 2026, but the value of the EU use will undoubtedly diminish over time. Turning now to reputation and whether your client's mark has a reputation in the UK. So to establish a reputation, the mark must be known by a significant part of the UK public concerned with the relevant goods or services covered. Post-Brexit, the same tests will apply with reputation acquired in the EU prior to 31st of December 2020 being taken into account for the enforcement of comparable UK trademarks in UK proceedings. Whilst this is the legal position, it will likely have little practical impact, and this is particularly in those circumstances where the use of the EU trademark from which the comparable UK trademark was derived was only in the EU 27, not in the UK. As we all know, the reputation has to be in the relevant country, so the UK here where a UK mark is being opposed or invalidated. However, after 31st of December 2020, a reputation in the UK will be required, and therefore it's important to start thinking about those sales, marketing income, and overall reputation in the UK if that's an important jurisdiction for enforcement. Here we have a timeline, which we thought would be a useful visual aid. Obviously, you'll get the slides after this presentation, so you can look at that in a little more detail. But it roughly sets out the position up to 31st of December and then afterwards.
Thank you, Lara. So keeping in mind this consideration, you have been instructed by your client to file an opposition. Here you are going to face an option. You can file a fast-track opposition or a standard opposition. A fast-track opposition is intended to provide a faster, cheaper, and less complicated way to business to resolve a trademark dispute. A fast-track opposition is made by the owner of an earlier mark, which is identical or similar to the opposed mark, and can only be brought on the ground of complete identity or likelihood of confusion. There is no need to file any evidence in the opposition proceedings. However, if the opponent's earlier mark is subject to use, the evidence needs to be filed at the time of filing the fast-track opposition. The average time taken to issue a fast-track decision is very quick because it is approximately 3 months. A decision in a standard opposition procedure would take approximately 12 to 15 months. However, the cost awarded in fast-track opposition are capped at £500. A standard track opposition is more appropriate where the opponent wishes to include a reputation or passing of claim, where the opponent has not prepared or finalized its evidence of use, where the opponent seeks to find evidence of confusion and enhance distinctiveness, surveys, reputation, or other evidence in support of his case. But before filing your opposition, whether it's a fast track or a standard track opposition, let's look at the pre-opposition action with Julia.
Thanks, France. So We discussed earlier the possibility for a potential opponent to file a notice of threatened opposition against the trademark application to extend the deadline by 1 month. This gives time, as we mentioned, for a potential opponent to try and reach a settlement with the other side, meaning that an opposition could be a last resort or could be not necessary. But it can also have favourable implications on a cost award that's issued in an opposition decision, because it shows that the opponent has used the proceedings as a last resort and has tried to mediate or settle the dispute prior to filing an opposition. This sort of behaviour and conduct is applauded by the UK IPO and awarded in the cost award that's issued in a decision by the UK IPO. So it may result in a reduction, for example, of any cost award by about £200. If no settlement is reached, an opponent may decide to move forward after filing that notice of threatened opposition with an actual formal notice of opposition. So to do so, no documents or powers of attorney are necessary, but different to the EU IPO, we are required to file a short statement of grounds along with the notice of opposition. So it's not a simple form like at the EU IPO. It's the form coupled with 1 or 2 pages of legal argument which sets out the main bases and grounds of opposition that's being filed. Once filed, the UK IPO will review the opposition, check the bases and grounds of opposition, so a formalities assessment, and then decide on its admissibility. If there's any confusion, perhaps if a trademark number has been put in wrongly or something like that, then the UK IPO will liaise with the opponent's representative on this prior to admitting the opposition. In that same correspondence, the UK IPO will set the date for the applicant to file its defence and counterstatement. And this is the same deadline as which both parties can jointly enter into a cooling off period. But, unlike at the EU IPO, if the applicant does not file its defence and counterstatement in an opposition, and a joint request to extend the cooling off period is not entered into, then the trademark application will be deemed withdrawn by default because of the opposition having been filed against it. This is different to at the EU IPO, where it's optional for the applicant to engage in proceedings. So it's not optional here in the UK. The applicant has to file a defence and counterstatement, and if it does not, its application will be refused to the extent of the opposition. The case won't proceed to a substantive decision on the merits. If the applicant does file its defence, the next stage of proceedings is the evidence rounds. And in the UK, evidence is commonly filed before legal submissions, separately, not at the same time, unlike proceedings in the EU, where they're filed simultaneously within one submission. So typically, the opponent has 2 months, first of all, to file its evidence in chief, and this is evidence of fact, so potentially evidence of use, evidence of reputation, evidence of confusion. The applicant then has its opportunity to file evidence in reply, and the opponent may have a final opportunity to file further evidence in response after that. So evidence is not necessary for a straightforward opposition based on a likelihood of confusion where the trademark, which is the basis of the opposition, where the trademark being opposed is not subject, where the trademark that's the basis of opposition is not subject to use requirements and does not have a reputation, so a straightforward case. Legal submissions can be filed at the same time as the evidence, but it's more common in the UK to file it later, at the final round of proceedings. So when we get to the final round, the UK IPO issues a deadline, and this is for the final legal arguments to be put to the UK IPO. These can be done orally through the requesting of a hearing where your representative can make the arguments in front of a hearing officer, or more commonly through written submissions where representative files arguments which is drafted by a certain deadline. The applicant will do so at the same time, meaning that there's not the sort of chronological back and forth that you have at the EU IPO. Arguments are filed simultaneously, and you don't have the opportunity usually to respond to anything because they're filed at the same time. So after this, typically, the hearing officer will review all of the papers which have been filed in proceedings, right from the very first notice of opposition and statement of grounds, any evidence, and then the legal submissions or the arguments that have been made at an oral hearing. and it will evaluate all of these and issue its decision usually within 2 months. At the same time, it might issue a cost award if costs have been requested. Now, there's a scale of costs in the UK, and typically for a standard opposition, you may expect a cost award to the losing party of up to £2,500. But this depends on the behaviour of the parties, and whether there have been any aggravating factors in the proceedings. The UK IPO's decision in an opposition is appealable by 2 routes. So first of all, potentially you could apply to the appointed person to appeal a decision, which is a senior hearing officer in the UK IPO, so a more senior registry official. But the downside of appealing to the appointed person is that no further routes of appeal are possible beyond this point. So if this is a case with sort of very complex point of law that needs to be decided on, the client may potentially not wish to appeal a case to the appointed person, but actually appeal to the High Court instead, which is the judicial body. And a decision issued by the High Court is further appealable in the UK, unlike the appointed person. Although obviously, being the High Court, which is the judicial body, this does mean that costs for this route of appeal are usually higher. In general, the costs of a UK opposition are difficult to quantify, but if we're taking a straightforward opposition, we'll say the filing of an opposition may cost around £1,200. And assuming no evidence is filed, so a straightforward case where you're just further drafting legal submissions later down the line, you could expect those to cost around £2,000 to £2,500. Costs for more complex oppositions vary quite considerably, but if we're talking about a case where there's a vast amount of evidence of reputation, there may be a hearing, there may be other issues which arise in the course of proceedings, costs may be upwards of £10,000, but we'd be able to give you an estimate and greater guidance on this as those issues arose and when we're examining the opposition and advising you on it.
Okay, so turning to litigation, I'll be looking at firstly some jurisdictional issues, which is one of the key changes for us post-Brexit. So Brexit has affected jurisdiction, service of claims and documents, recognition of judgments and cross-border enforcement. A preliminary point, which I know is always quite confusing, is that when we say references to UK courts, we're really referring to the jurisdiction of England and Wales. Ireland and Scotland are not included and are separate. Since the end of the transition period, 1st of January 2021, UK courts have no jurisdiction to hear new cases based on EU rights or to grant remedies affecting EU trademarks, including cancellation and pan-EU injunctions. Therefore, proprietors of EU trademarks and community designs and those corresponding new UK rights will have to litigate twice in order to prevent infringements in the UK and in any EU country, once in the EU and again in the UK. For trademark infringement actions, it remains the case that the infringing act must have taken place in the UK for UK courts to have jurisdiction under the now common law rules and, where it applies, the Hague Convention, and these both now apply in default post-Brexit. The key distinction between the previous EU regime and the UK common law rules is that the basic default principle that defendants should be sued in their country of domicile no longer applies. In some respects, the common law rules provide a more expansive basis on which the English court can assume jurisdiction over defendants domiciled outside of the jurisdiction. The Hague Convention on Choice of Court Agreements gives effect to exclusive choice of court agreements, which designate the courts of a contracting state and requires contracting states to recognise and enforce the resulting judgments. This has more importance now that the UK has acceded in its own right to the Hague Convention, and so it applies to determine jurisdiction where there is an exclusive choice of court agreement designating the courts of the UK, an EU member state, Mexico, Singapore or Montenegro. There is likely to be an increased risk of challenge to UK jurisdiction by UK domiciled defendants post-Brexit on the basis that England is not the appropriate forum for the resolution of the dispute. So this is under the recast Brussels regulation. The English court cannot decline jurisdiction to hear a claim against a UK domiciled defendant on the basis that England is not the appropriate forum, except in limited circumstances. Another clear point is that careful drafting of jurisdiction and choice of law clauses post-Brexit has now become very important. For those that have historically always used English governing law and jurisdiction for all of their agreements, there is a new wrinkle that if the subject matter of the agreement concerns the validity or infringement of an EU trademark, the UK courts will no longer be able to rule on such matters. So those specific issues will need to be determined by an EU trademark court, for example, in an EU 27 country. Therefore, parties will need to agree in advance the alternative jurisdiction for that pan-EU relief. The best practice may be to have the agreement itself governed by English law and to have a non-exclusive jurisdiction of the English courts for disputes arising out of it. That leaves the option of an EU trademark court to deal with any infringement or validity issue, but it would be preferable to specify which one, not least if you have a language preference for the litigation. So EU IPO torpedoes, this is a well-known defendant's tactic that already exists, but post-Brexit, it's likely to be used much more often by UK-based defendants who fear being sued in a foreign EU court, which has the power to grant a pan-EU injunction and damages against it. A UK defendant expecting such a claim may choose to take a preemptive attack in an effort to dissuade their opponent, for example, by filing a preemptive attack against the EU trademark before the infringement claim is started, so that the claim has to be stayed until the registry attack has been finally decided. The counter tactic would be to just sue the UK defendants in the relevant EU court without warning. However, this has the negative of dissuading Preaction correspondence, and as I'll come on to later, this is very much encouraged by the English courts. UK law has already started to diverge from EU law, and we believe that we'll see much more of this in the future. So an example of this is with the concept of targeting in the UK, and a well-known position in EU case law. The recent Lifestyle Equities and Amazon Court of Appeal case reinterprets the idea of targeting UK consumers where there is online infringement. Targeting isn't defined in the legislation, so it is open to divergence between the EU and UK positions. The decision found that the US listings of products bearing the Beverly Hills Polo Club trademarks on Amazon's global store constituted use of the trademarks in the UK, as the products were also available for purchase by UK consumers via the .co.uk website and could be purchased through the .co.uk store. This is an example of where the UK courts might be inching away from EU case law by considering the concept of targeting to be too narrow and taking a broader interpretation of use in the UK to be sufficient. So moving on to choice of forum. In the UK, for trademark infringement disputes, there are broadly three options to choose between. And this is the General High Court, which is the column to the left, the Shorter Trial Scheme, and the IPEC. So the High Court, which is at the top of the scale, has no caps on damages or costs, no inherent limits on timetable, and the trial is often 18 months from issue. The Shorter Trial Scheme, which is available as part of the IP list in the Chancery Division, is most suitable for time-sensitive cases of moderate complexity, given the 4-day trial limit. It requires little evidence or disclosure and is also preferred where damages may exceed those recoverable in IPEC, or the cost caps are not desirable. The procedure is effectively a hybrid between the normal procedure and that of the IPEC. The IPEC. So what does that stand for? That's the Intellectual Property Enterprise Court. So the IPEC is intended to provide a cost-effective forum to hear intellectual property claims as an alternative to the High Court. It generally takes anywhere between 12 and 18 months from issue of proceedings to trial, with the duration of trial lasting no longer than 2 days, So it really is for those disputes which are much less technical in nature and much lighter in terms of evidence and documents. The choice of forum can have a significant impact on how the case will run procedurally. It can impact strategy, timescales, and costs incurred, and the costs that parties can recover, and ultimately the remedies available to the parties. So key considerations when deciding on forum, and you'll see on the screen that there's a nice tabular format setting out the kind of comparison across timescales, Preaction, pleadings, case management, evidence, disclosure, cost budgeting and management, and cost recovery and damages. So digging into these in a little more detail, the value of the claim, and this is including the value of an injunction. Generally, cases worth more than 500,000 should be started in the High Court. Lower value cases may be suitable for the shorter trial scheme, and cases worth less than 500,000 but more than 100,000 could be started in the IPEC. Disclosure. So in the IPEC and the shorter trial scheme, there is no standard disclosure. Disclosure results from requests at the case management conference or subsequent application and will therefore always need the approval of a judge. Complexity and evidence. The IPEC is suitable for trials lasting up to 2 days. The shorter trial scheme can accommodate trials of up to 4 days, and more complex cases will need the procedures of the High Court. Evidence in the IPEC and the shorter trial scheme has to fit to the time allowed, so neither are suitable for cases involving substantial disputed evidence. And in fact, judges have been quite critical in recent case law of where cases have been started in the wrong forum when it should have clearly been, so for example, started in IPEC when they should have clearly been started in the High Court based on the sheer complexity of the matters involved. Costs. So the High Court is the most expensive forum. Running a case using the shorter trial scheme will significantly reduce these costs, and the IPEC is even cheaper, but it should be noted that recoverable costs are limited by the cost caps, and that's capped at each stage of the litigation. So whilst there is a total £50,000 cap on costs, which is increasing in the next coming months, that will still be capped at each level. So, and obviously we all know that it's unlikely that you'll get all of your costs back. So that 50,000 is a limit. Costs in, say, the cost of a case in IPEC can range from £250,000 upwards. So that's obviously important to also bear in mind in terms of the cost cap. The UK IPO will be cheaper still, but its jurisdiction is limited. And as Julia mentioned, the cost recovery at the UK IPO is even more limited. Turning now to the various stages of litigation, we decided, as some of these may be quite similar in your own jurisdictions, to focus on those that have more unique aspects in the UK. And this is kind of a rough stage, but each will differ depending on what track you ultimately are on. So the pre-action phase, this concerns the steps taken prior to issuing proceeding and includes all those steps taken in effort to settle the dispute outside of the court. The requirement to take such steps has a significant impact on cost recovery, and if you're a defendant in the IPEC, can even extend the time you have to file your defence. So this gives you 70 days. In the UK, there is another quirk to the pre-action stage known as unjustified threats. So potential claimants should be aware that in the UK, there is legislation which could entitle a defendant to bring a counterclaim against a claimant where the correspondent constitutes an unjustified threat to bring infringement proceedings. A communication will constitute a threat if it would reasonably be understood by the recipient to mean that someone intends to bring infringement proceedings in respect of the relevant IP right for an act done in the UK. There are a number of exemptions from liability. So, for example, for primary actors of infringement, for trademark where they're applying a sign to the goods or their packaging. And it's also a defence to a threat claim to show that the act to which the threat relates was or would be infringing. But obviously you've got to prove that. The legislation was primarily introduced to prevent rights owners from making threats of infringement proceedings in correspondence where there is no merit for doing so, or say contacting the retailers of the infringing goods downstream as opposed to contacting the primary actor. I will go into more detail on disclosure below, but it can be a particularly powerful pre-action tool. This is whether through the civil procedure rules on pre-action conduct. So this is the requirement to disclose all relevant information in initial correspondence, or by taking that extra step and making an application for pre-action disclosure of relevant and potentially harmful documents. This is obviously quite important for claimants because the more information you have, the better your claim will be. Case management conference. So the case management conference is a preliminary hearing which gives the judge, with the assistance of the parties, the opportunity to manage the conduct of the case. This is so that proceedings will move forward to trial in an efficient and proportionate way, in line with the nature of the dispute. At the CMC, the court will identify issues of fact and law to be resolved at the trial and will decide what orders are required, including for disclosure, witness statements, expert reports, if there are any, which we know they're pretty rare in trademark infringement disputes, and skeleton arguments. So this kind of active case management, I think, is particularly unique for the UK, and appears to be quite different to approaches taken in EU counterpart countries such as France or Germany. Disclosure. So disclosure means formally stating that documents or classes of documents exist or have existed and making them available for the other side to inspect. The obligation is to conduct a reasonable search for and disclose documents, and that's including all electronic documents, currently or formerly in a party's control. So this can be quite an onerous search obligation, and it's important to make sure that your client is aware as soon as litigation becomes a possibility that there's a requirement that parties preserve all relevant documents, and the duty of disclosure continues until judgment or settlement, and the failure to comply can lead to considerable cost consequences. There is an exception for privileged documents, so whilst they must be disclosed, they may not be inspected. And the extent of disclosure will depend upon the precise order. So, as I noted before, depending on the forum you're in, if it's High Court, it will be likely standard disclosure, whereas if you're in the IPEC or even the shorter trial scheme, you're likely to get a much more specific order that the disclosure of specific documents or classes of documents. So that's a rough run through of the key stages that we wanted to focus on. I think that's probably all we have time for on the overview of the court procedure. And I'll now hand back to France, who I think is going to close out the session for us.
Thank you, Lara. So we are at the beginning of a new era. And as you mentioned, Lara, we believe that the divergence between the UK and EU law and practices will only increase in the future. However, for now, we think that the key takeaway when advising clients are as follows. So if we look at pre-action, there are very important steps, and as we have seen, they have cost consequences. Consider your route when dealing with the UK, whether it's a fast-track opposition or litigating in the IPEC. Both are cost-effective options. Don't forget to consider unregistered rights, whether they are your client unregistered rights, but also those of your opponents. Finally, don't forget us. If you need help, we are here to help. That brings us to the end of our today presentation. We have had some questions, so maybe I will start with the first one. The question is, as in the EU, can I file an opposition and withdraw it at any time before a decision is made? Julia, do you want to take that question?
Absolutely. So an opponent can withdraw an opposition at any stage of the proceedings. And I think quite helpfully, because we have that quite rigorous timetable in the UK, you know exactly where you are in proceedings, you know roughly how close you are to a decision or, you know, to any other deadlines which are occurring, which is not always the same as at the EU IPO, where sometimes you don't know if your submissions have been notified to the other side. You know, you don't know if a decision is, expected next day or something like that. So you can always withdraw an opposition prior to a decision being issued in the UK. It's just that a cost award may be made against you if you're doing it at certain stages. So even if you're withdrawing an opposition after the other side has engaged, but only a little bit, you should expect a cost award to be made against you if nothing, has been lost, if you like. So no specification limitations have been applied by the other side. And we touched on cost awards before, but just to note that if the opposition is being withdrawn at an early stage, a cost award could be made against you of approximately £200 to £600, for example. If it's at the very late stage, just before a decision is issued, then it might be, as we discussed, up to about £2,500.
Thank you, Julia. The second question, I think, will be for you, Lara. Can I start a case in the IPEC and then move to the General High Court?
So the simple answer to that is yes. So if a party wishes to transfer the case in the example where you say between the IPEC, from the IPEC to the General High Court, and there may be many reasons that you choose to do this. Some examples are that some disclosure makes you realise that you need the damage, the caps on costs and damages to be lifted, or you just simply decide that the complexity of the case is beyond that of the IPEC. So the first thing to note is that you should always approach this by correspondence. So the party wishing to make the transfer should write to the other party to seek agreement. If the parties both agree, then it will still need judicial approval, but that will almost always be granted if both the parties agree. If one of the parties does not agree to the transfer, the other option is to make an application to the court. So the application should be made before the stage of the CMC, ideally, and that's kind of your rough options in your control. I guess the other point to note is that the judges also have their own allocation powers. So as I noted, there's been some judicial disapproval to those cases that have been started in the wrong forum, and they do have their own powers to transfer claims started in the wrong forum of their own accord.
Thank you, Lara. I regret that's all the time we have for your questions. So if you have any other questions and they have not been answered, we will contact you directly to follow up. As we said at the beginning, we will make the recording available so you can rewatch it if you really fancy that, or you can pass it on to your colleague. You're welcome to send us any additional question you may have. Please, give us your feedback on this seminar. It's very useful to us. And that just leads me to say thank you for joining us today, and thank you to Lara and Julia for their valuable contribution. Goodbye.